Intellectual property. It's something that you can't touch, hold, or physically lock away for safekeeping. If you can't lock it up, then how do you protect it? That depends on what type of intellectual property it is. Lucky for us, there are only three: patent, trademark, and copyright. A patent gives its owner the legal right to exclude others from making, using, selling, and importing an invention for a limited period of years, in exchange for publishing and enabling public disclosure of the invention with the U.S. Patent and Trademark Office, also known as the USPTO. The idea may seem complex, but it's not so bad. Some call it a Faustian bargain, referring to the legend of Faust giving up his eternal soul to the devil in exchange for knowledge and pleasures during his lifetime. Your soul is your invention, your blueprints, and your formulas. You give these over to the government for the world to learn from in order to gain up to a 20-year exclusive monopoly over your invention. A trademark is any word, name, symbol, device, distinct colors, sounds, designs, or combination thereof that is used by a company or individual to distinguish its goods and services from those produced by other companies. Rules of trademark are very important. Number 1. Generic terms cannot be trademarked. Number 2. Failure to use and defend the name for 3 years constitutes abandonment. And number 3. If you want to secure a permanent trademark, you need to complete 4 tasks. These tasks are to file for your trademark, renew it after 5 years, renew it again every 10 years after that, and you must defend your trademark against those who try to use it or use a name similar to your trademark. Lists are so fun. Let's do another one. The 4 functions of a trademark and service marks are: 1. To identify your goods and distinguish them from the goods sold by others. 2. To signify that all goods bearing your trademark or service mark come from a single source. 3. To signify that all goods bearing your mark are of equal quality. And 4. To serve as a prime instrument in advertising and selling goods. The key is that trademarks are established to prevent confusion in the marketplace. If you want to buy a specific brand, you, the consumer, should not be confused by lookalikes. What a mouthful. And we still have one more type of intellectual property to look at: copyright. It is the body of law that protects the works created by writers, painters, photographers, performing artists, and others who create intangible property. Let's get more specific about what can be copyrighted and what cannot. You can copyright literary works, including software, musical works, including accompanying words, dramatic works, including any accompanying music, pantomimes and choreographic works, photographs, graphics, and sculptural works, motion pictures, and other audiovisual works and sound recordings. Well, is there anything that can't be copyrighted? Of course, you cannot copyright ideas, facts, research, titles, or methods. With a copyright, you get some exclusive rights: the ability to reproduce the work, ability to prepare and create derivative works, publicly distribute the work, publicly perform the work, publicly display the work, and publicly perform a digital sound recording. To register a work, you must fill out an application with the U.S. Copyright Office, pay a fee that varies upon the nature of the work, which could be as little as $45. You can visit www.copyright.gov to learn more. And you'll need to provide at least 1 copy of your work. It is advised that you register your copyright before your work is published, but there is a 90-day grace period after publishing or viewing to register for the same level of protection. So, how do you know if a work is copyrighted? Typically, you can see a copyright notice on the title page or clearly visible on a DVD or CD or web page. This notice consists of 3 parts. 1. The copyright symbol, a C in a circle. 2. The year of publication. And 3. The name of the actors, creators, or the company that owns the copyright. Let's wrap up copyright with a quick history lesson. In 1790, the Constitution went into effect, containing Article 1, Section 8, Clause 8, which states that Congress has the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Authors and inventors were initially granted copyright protection for 14 years for books, maps, and charts. If desired, and for a fee, this copyright protection could be extended for an additional 14-year renewal period, equaling a maximum duration of 28 years. In 1802, copyright protection was extended to prints. Then, in 1831, the duration of copyright protection was extended to 42 years, an original grant of 28 plus 14-year renewal. In 1909, protection was broadened to include sheet music, and the copyright duration was again extended to a possible 56 years, an initial 28 plus a 28 renewal period. The Copyright Act of 1976, Title 17 of the U.S. Code, brought big changes. This act strengthened the exclusive rights of authors. It preempted virtually all state laws and extended copyright duration to the life of the author plus 50 years. Then, in 1988, Congress approved U.S. participation in the 102-year-old Berne Convention, an international copyright treaty. Now, U.S. citizens' copyrights were protected worldwide. Most recently, in 1998, the Sony Bono Copyright Extension Act, aka the Disney Act, was enacted. This act granted extended copyright durations. Any works created before January 1st, 1978 are now granted exclusivity for 95 years. Any works created after January 1st, 1978 are now exclusively held for the life of the creator plus 70 years. Works created by more than one person are good for the life of the last living creator plus 70 years. The last change concerns works made for hire, which refers to the ability of a company to own a copyright developed from the work of their hired employee. Under the Sony Bono Extension Act, works for hire are now protected for 95 years after publication or 120 years after creation, whichever ends first. This is a lot of information, no doubt about it, and it's only a quick summary. The most important takeaways are to not steal other people's work and to do research on your specific creation so that you can protect yourself and your art because it is your hard work at risk.